Hi, it's Connecticut car accident attorney Ryan McKeen here. Today I'm going to talk about a car accident complaint. Now, what is a complaint? Now, before I was a lawyer, a complaint was something like, you ordered a meal and it came with frozen butter or something, and you may complain to the waiter and say, well, this butter's frozen, I can't butter my roll. That's sort of how I think normal people classify what a complaint is. But in law, a complaint has a completely different meaning, okay? In Connecticut, a complaint is a legal document, and it's usually written by an attorney. You can write them yourself. There's no law that says you can't. But it is a formal legal document that kicks off the lawsuit. So you can look at it in any lawsuit as if it were a football game. This is the kickoff. This is when you are telling the other side, and you are telling the court, and you are telling the world, really, this happened. This is who's responsible. So you're going to say, well, look, this is the thing that happened. It was a car accident. It was on this day. It was in this place. It was on this road. It was at this time. These were the drivers. It was a public road. These were the injuries suffered. The injuries suffered are caused by the car accident. There have been damages that have happened, such as medical bills, future medical bills, lost wages. There are also, and these damages were specifically caused by this car accident, okay? So a complaint is going to lay that out, and there may be multiple counts in a complaint. So, for example, you may have a count that says, well, look, you have, the person was negligent. They weren't paying attention when they were driving this. So it's the same incident, but you may also have a count that says that they were reckless. For example, maybe they were on their cell phone. Maybe they were drinking and driving. Maybe they were operating under the influence of marijuana. So you have all these other things that could be reckless, and so you're telling the court they were negligent. Here's what happened. My theory is that they were negligent. My other theory is that they were reckless, and here are the damages that I'm asking for. For negligence, I'm asking for economic and non-economic damages. And for recklessness, I'm asking the judge for punitive damages. I'm asking for 2 or 3 times what the damages are for negligence. So you're telling the court all of this information, and it's a document that under Connecticut law has to get served on the defendant, the person who caused the accident, and then it comes back to the plaintiff. The law office gets it. They scan it. In today's world, everything has to be electronically filed. They upload it to Connecticut e-services, pay a entry fee, and then that complaint gets lodged with the court. And it gets, that starts the lawsuit process, and it starts deadlines. The deadlines essentially begin by starting with something called the return date, sort of beyond the scope of this video, but just know that a defendant has to appear within 2 days of a return date, or they can be defaulted. So it starts sort of the litigation timeline with that return date. Now, a complaint is actually different than filing a claim. When we talk about filing a claim, we are letting the insurance company, your insurance company, the person who hit you, we are letting them know that we are making a claim. It's not done with a court. It's done simply with the insurance company, so they can open up a claim number, they can assign an adjuster, we can begin to negotiate that. So not every claim results in a complaint, because sometimes you are able to settle your case. Sometimes it requires a lawsuit. That's when a complaint comes in. So I just say this because this is something that, if you're not a lawyer, and I wasn't a lawyer, none of this would have made any sense to me. But you may hear these different words, and I hope this helps you in some way. If you have any question, don't hesitate to give me a call, 860-471-8333.